All right. Both sides are ready. Let's have the appellant acknowledged by taking your mic off. That would be Mr. Nesbitt.
No, Your Honor, I believe that would be Mr. Carey.
Carey, okay, your mic is still on then, on mute. Mr. Carey, your mic is still on, off. You trying to figure it out? I'm the last guy to advise you how to do that. You got a mic button on your screen?
Mr. Carey, if you look at the bottom left-hand side of your screen, there's a mute button.
Okay, I got it up.
Check it.
Okay, beautiful. All right, so we ready to go?
Yes.
All right, would
Sorry.
you like some rebuttal time?
Yes, I'd like to reserve 3 minutes for rebuttal, please.
You got it, sir. I'm going to
Okay.
begin your 20 minutes now.
May it please the court, my name is Michael Carey, and I represent the appellant Hayward Baker. The issue before the court today is whether the trial court erred in finding that there was no prevailing party in the two consolidated cases below, even though Hayward Baker achieved 100% of the benefit it sought in both cases, and the appellees achieved no benefit whatsoever.
When you say benefit, that's unrelated to the amount. He sought more amount, but that was the benefit. Is that correct?
They received zero
Okay.
in both cases. They
Well,
were, in the first case, Westfield,
Let's talk about your client.
well, my client received 100% of what it requested in both cases.
He wasn't asking for more money?
No, sir. We got every dime we asked for. We asked for $290,000 in the first case and received it. We asked for $290,000 in the second case and received it.
But they achieved a finding that your client was liable for some of the damage.
There's a glitch on Judge Atkinson's. No, you hit the, you're fine. We just couldn't hear you. Internet must be fading in and out.
Oh, okay.
Now it's back. You're back.
What was there not a benefit to the jury finding that your client was responsible for some of the damages?
No, there was no benefit. And the reason there was no benefit is twofold.
There was
One,
no net benefit, but wasn't there a benefit? I mean, it
No.
couldn't have gone worse for the opposing party. Couldn't have gone, in other words, couldn't the jury have said subcontractor's not liable at all?
it wouldn't have mattered because they'd already received all the money that the jury found Hayward Baker was responsible for. And they'd received that money 4.5 years prior to trial from Hayward Baker's insurance company.
Mr. Carey, if I can jump in, I think as I understand it, the only way that this trial would have been any benefit to Diaz they would have had to have received an award of something approaching 100% of their claim, because otherwise the $450,000 settlement was going to consume whatever it was they recovered from your client. Is that right?
Yes, sir. They
That's
had to get over that hurdle and they couldn't do it.
So you're claiming error below because the judge didn't feel that the set off was something to be considered. Is that right?
Yes, sir. The court totally ignored the set off. It mentioned set off. It mentioned set off was the single biggest economic value in the case, yet inexplicably made the statement that set off didn't affect the outcome of its prevailing party determination.
Now, let me ask you this: the $450,000 set off, was that achieved? Is that something achieved by the attorneys seeking fees?
Yes. There was
How was that in dispute?
there was an argument by Diaz Fritz that we were entitled to no set off. And they argued that both in front of the trial court at 3 separate hearings and lost, and argued on appeal before this court and lost. So set off was the single biggest, not only the economic value of the case, but also it controlled the case. It changed this case from what might have been a close case to a complete victory for Hayward Baker. And that's where the trial court erred, is that they didn't properly consider the set off. Moritz Supreme Court says you need to take into account. Salame out of the 3rd district says you need to take set off in account. And if you don't, it's error. and was
Now,
clear.
is it possible that the trial court did take it into account and still said, you know, nobody won on the significant issues?
Well, okay, and that brings us, I guess, to the court taking account, it mentioned it in its order. There's no question it mentioned it in its order. But then, and it mentioned that it had the single biggest economic value. But then it makes a statement, which, like I say, you just can't reconcile with the case law. And what they said, what the court said, is that the result of the set-off won't affect its determination of prevailing party. So in essence, they ignored set-off. There's no way to find no prevailing party unless you ignore set-off. Because if you take into account
My
set-off,
question to you is I was wondering if you could speak to the evolution of the standard that was discussed in the briefs. And one way that opposing counsel may or may not characterize your argument is that you're reverting to the standard that was superseded, and you're just arguing a net win standard. In other words, the on net, your client came out ahead, therefore you're the prevailing party. And wasn't that superseded by a standard that gives, to me, it seems gives a lot more discretion to the judge?
okay, here's the standard as announced by the Moritz and as followed by Tritech. It is the party who prevails on any significant issue in the case that achieves some of the benefit sought by the parties in bringing the case. If you break that down, there are two prongs to it. One, you must prevail on a significant issue, but two, it must achieve some of the benefit the parties sought in bringing suit. Okay, what were the benefits that the parties sought in bringing suit? Hayward Baker sought to recover $290,000. In the first case against Westfield, it achieved that benefit. Westfield sought to try to avoid being liable for that $290,000. Westfield did not achieve that benefit. So in the first case, Hayward Baker's the prevailing party. In the second case, Diaz Fritz sought to recover $581,000 from Hayward Baker. Hayward Baker sought to recover $290,000 from Diaz Fritz. End result of the second case was a final judgment. That final judgment was in favor of Hayward Baker for $290,000 plus prejudgment interest. So the only party who achieved the benefits sought in both cases was Hayward Baker. So we are not arguing for a return to the net judgment rule. We are arguing strictly on Moritz and Tritech, but you've got to look at both prongs of the rule announced in Moritz. And that's where the trial court erred. It failed to look at the benefit achieved. And the second thing, and that was error. The second error it did, and it's related to that, is that instead of looking at the final judgment to determine prevailing party, the trial court looked at the jury verdict and a finding a jury verdict. And we admit there's a finding in the jury verdict that Hayward Baker was responsible for some of the damages. But that finding did not translate to a benefit as required under Moritz. And the reason it didn't translate to a benefit was because of the set-off. Because Diaz Fritz had received $450,000 from the insurance company 4.5 years prior to trial, took the position that it could keep that money and give no set-off against the $581,000 of additional damages it was seeking. So Diaz Fritz, armed with that $450,000, forced a jury trial, continued litigating for 4.5 years, forced a jury trial on an erroneous legal position that there was no set-off. It lost that position. It lost it at the trial court and it lost it before this court. So, looking at the finding of fact in the jury verdict was an error by the trial court. If you look at this court's decision in Tubbs, the court says you look at the substance of the litigation outcomes at the end of the case, namely in the final judgment. You don't look at a preliminary jury verdict before the set-off issue is determined.
Would it be, I can't do the math in my head as quickly as I need to, but would it be safe to recharacterize or take from what you just said that there was no way that Diaz was going to be the prevailing party in the event that Hayward prevailed on the $450,000 set off, because no matter how high or low the jury verdict regarding the damages for which Hayward was responsible would never made any difference, would never have been a benefit given the set off. Is that right? I mean, I'm just trying to do the math in my head.
It would be difficult for Diaz Fritz to prevail, and that's one reason why, frankly, we couldn't figure out why they kept proceeding.
Diaz Fritz had said 100. It said, you know what, Hayward is 100% liable. The whole mess is their fault. Would it, even given the set off, would that have been a benefit? In other words, how does the math go?
Okay, well, the math there would go $581,000 Diaz Fritz was seeking. You subtract out the $450,000 set off, assuming we won that issue. Of course, they contested it. That would bring you down to 131. They still owe us $290,000 on the contract. So they still would end up, you know, you talk about a net judgment, that might be a net judgment argument. But here,
or alternatively say that you're saying a benefit. In other words, they would never have benefited.
correct.
Well, it seems to me that if Diaz had won something approaching 100% of their claim, then at least they could have made a good faith argument that they achieved some of the benefit. They would have had a better, stronger case. But
Agreed.
in light of the fact that they were only awarded half of what they were after and were not able to get beyond the $450,000 Zurich settlement, then they don't have that argument available to them.
Exactly right. The set off totally changed the complexion of this case. It might have been a close case, it might have been a tie, but for the set off, but the set off was a critical issue, and that's where the trial court erred. And really, although acknowledged it, it didn't consider it in its prevailing party determination, and therein lies the error. So to kind of sum up, you've got three errors by the trial court in its prevailing party determination. One, it did not consider the benefits achieved by the parties as required under Moritz and Tritec. Two, it didn't look to the final judgment to determine prevailing party. Instead, it looked at finding a jury verdict that effectively was superseded by the set-off. And three, it failed to properly consider set-off. The final error we've contend in our brief, and I'll rely upon the briefs for that, is the trial court failed to separately analyze the attorney's fee claim against Westfield in the first case. It instead combined them both, and under the Dex and such case we cited in our supplemental authority, that was error. But it really, you know, it really comes back to the trial court not considering set off and not considering benefits achieved. So if you don't have any further questions, I'll reserve the rest of my time.
Let me just put one more thing in front of you that I'm anticipating will be argued shortly, and that is that the $290,000 that was awarded to Haywood Baker was as a result of a stipulation rather than an achievement at trial. There seems to be some intimation in the briefing that that makes a difference. Would you care to comment on that?
Sure. First of all, that argument ignores the record because it wasn't until literally the eve of trial that stipulation was made. That $450,000, excuse me, that $290,000 was contested all the way up, including Westfield forcing a bench trial, bifurcated bench trial on the timeliness of the lien. So it wasn't until we won that issue and won, you know, and essentially they realized the handwriting's on the wall, they stipulated at the very last minute. So I don't think that makes any difference, but the fact of the matter is that under the record evidence, that was a hotly contested evidence until the pretrial conference.
Can I ask one more thing as well? I don't know, you can tell me if he's still in his, close to his reserved time, but you're arguing for a de novo standard of review, and what it sounds like to me is essentially almost a certiorari argument, meaning that the trial court applied the wrong law, therefore it's a legal issue. You know, departed from the essential requirements of law by not taking into account the set off, but we're not in certiorari, and this is and it's possible that the trial court, you know, that he or she knew there was a set off. Why is this not just an abuse of discretion standard? I don't understand how you jump to a de novo.
Well, The reason we contend it's de novo is because we believe there were errors of law in failing to properly apply the legal standard. As I said before, the trial court only applied the first prong of the Moritz standard, not the second. But make no mistake about it, it's our contention that whatever standard of review is applied, whether it be abuse of discretion or de novo, that the trial court erred. And under the facts, which are undisputed at this stage, there was an abuse of discretion. The ERHM orthopedics case, directly on point, same trial judge, same error, found no prevailing party, didn't consider the benefits achieved. And so, like I say, regardless of which standard applies.
Well, if it was abuse of discretion, we'd have to think that no judge would have concluded that, even taking into consideration the set off, that no party prevailed on the significant issues achieving a benefit.
Okay, and you know, and there was no benefit achieved. ERHM orthopedics decided last year.
But that's not what we're here on. We're not here on whether the opposing party achieved a benefit. We're here on whether your client achieved, prevailed on the significant issue with the benefit.
Correct. And when you achieve 100% of what you're asking for and prejudgment interest on that amount, I don't see how any other conclusion could be arrived at. So whether abuse of discretion standard applied or de novo, it was error and should be reversed. Thank you.
All right, you've got about 4 minutes if you want to keep it for
Thanks, sir.
rebuttal.
Okay.
Mr. Nesbitt?
Yes, may it please the court. My name is Rusty Nisbet. I represent the Diaz-Fritz Group and Westfield Insurance Company. I will refer to the Diaz-Fritz Group as DFI, Hayward Baker as HBI, and Westfield Insurance Company as Westfield, so that it's not too wordy. Now,
Nesbitt, given what happened with the set off, that it was used to set off the damages that were achieved by your client at trial, what benefit was the trial to your client when the dust settles? What did they get out of it?
Your Honor, I think the court has to look at the complete history of the case, because I believe that under TriTech, it believes it's a flexible rule and it's based upon equity and fairness. And I think if you look at the
equity and fairness, I don't understand that. Your case was settled with a $450,000 settlement by the insurance company. Your client elected to press forward to trial, which of course is their right to do. And had they achieved their goal of 100% or near thereof recovery, then you might have had something. But as it turned out, nothing of value was accomplished by your clients going to trial.
Well, Your Honor,
that I can find.
Your Honor, we did get a finding that the HBI breached the contract and was responsible for more than half of the water.
What benefit did your client derive from that?
It's the same amount that Hardiman, in the Hardiman case, was derived when there was no damages awarded under that. And this court held that the focus on the prevailing party was the prevailing, who prevailed as far as in a breach of contract case, who breached the contract. In the ERHM case, it was the same thing with the non-compete agreement. That individual breached the non-compete clause of the agreement. And Hardiman, it was the homeowner, Watkins, who breached the contract, but the landscape company, Hardiman, got nothing. And the court focused on, in fact, specifically identified that when,
The benefit your client sought in bringing suit is the language from ERHM, which is our second DCA very recent case. The benefit you were seeking by going to trial wasn't to have a fact finder say, yeah, you're right, they're responsible for half of it. What you were after is money, and that's what you didn't get. And that's where I'm not following you.
All right. Well, I think it's best to start at the beginning because that's the most important. And at the beginning, this whole case resulted because of the actions and the harm that was caused by HBI. HBI was the foundation subcontractor on a 5-story addition to a hospital. As a result of its jet grouting operation, it piled up spoils and dirt on the thing, and because of that, it caused a flooding to the hospital. They, under the 4.15, it's a section of the subcontract. If damage is caused to the hospital, the subcontract is responsible for remediating it timely. If it doesn't, then DFI can step in and charge the costs against the subcontractor. 6 months went by, HBI did nothing. All DFI.
How does that address Judge Black's question about what the benefit was from the jury's finding of a breach that caused damages?
Well, we wanted money, and the jury's finding was after the judge was $272,000. That was
The money you achieved as a result of that accident, or whatever you want to call it, is the $450,000 insurance settlement. So,
well, in both Prosperi and Moritz, the set-off wiped out any kind of monetary relief and ended up with a net judgment against the prevailing parties. The same
in those
thing
cases, was the set-off contested? Counsel for Hayward is saying that the $450,000 set-off, and that actually makes intuitive sense even without a review of the record, because you went to trial. So if there was no question about the $450,000 set-off being in play, then why would your client have ever gone to trial when there was a slight margin of a chance you'd get something after the set-off?
Your Honor, you are absolutely correct. My client truly believed that there was not a set-off right. And when it entered into that $450,000.
That sounds like, since we're not really here on whether your client should have been the prevailing party and gotten fees, we're here on whether the opposing party should have gotten prevailing party fees. That sounds like an achievement of a significant issue. In other words, an issue that was so significant that had you known you were at a loss, you would never have gone to trial. And the Hayward won. And can you say there was no benefit?
No, what I'm getting at is, Your Honor, is that in the Zurich case, that case lasted 18 months in federal court. DFI incurred $336,000. This is undisputed in attorney's fees and costs, and it ended up getting a $450,000 settlement. So I think the equity, you got to look at, well, what did DFI get out of it? Did it get 450 grand? No, it did not. It got a net amount. All it wanted was HBI.
Which it would not have gotten which it would not have gotten if that significant issue of the set-off had not been an issue on which they prevailed, right?
Well, that's the set-off was it was an issue, and it was considered by the court. It was considered by the court because the court listed out what issues HBI prevailed on and what issues DFI prevailed on. And the set-off was considered by the trial court, and the trial court still ruled. I think you go back to the principle that was espoused by this court in Hardiman, which is that a finding that one party breached the contract makes the opposing party the prevailing party on the litigation significant issues, even when no damages are awarded. And so
we're not here on whether your party prevailed.
No, I know that,
but on whether Hayward prevailed on a significant issue that afforded them a benefit and in light of that, failure to consider them a prevailing party and award them fees was an abuse of discretion. So we're not here, am I correct? We're not here on whether your client was the prevailing party.
No, we're here on whether or not the court abused its discretion in determining that there was no prevailing party, because each party prevailed on significant issues. And that's what we're here for. And it's our position that the trial court did not abuse that discretion based upon the Hardiman decision and all the other cases in which any net amount that was awarded got nullified as a result of either a set-off or some other way.
Okay, so look, the cases you're talking about are cases in which there was an award of fees even though the awardee did not win on net. What cases do you rely upon where a trial court where there was no award because, essentially they were offsetting benefits based on offsetting prevailing significant issues?
Well,
Because that's what we're here on. We're here on whether it was an abuse of discretion to award no fees based on no prevailing party.
well, Your Honor, I believe that happened in the Prosperity case, Your Honor, the Florida Supreme Court case. Or is it, hold on a second. No, I'm sorry, it's Moritz. In Moritz, the homeowner put down a $58,000 deposit. The contractor contested that the $58,000 constituted liquidated damages, filed a motion for partial summary judgment, and lost. It was a contested issue. They lost. After the offset of the $58,000, it ended up with a net judgment in favor of the homeowners, but the homeowners are the ones that breached the contract, and the Florida Supreme Court held that the contractor was the prevailing party. So I would say that case is the best example. But the other example is Tritech, in which the homeowner hired an insulation contractor, and in performing the insulation contract, they damaged the electrical system. And so there was no dispute that the installation was installed correctly, just like with HBI. It has not been a dispute that the $290,000 was owed. It was just that the cost of remediation or repair would far exceed that amount, and that was a credit that DFI was entitled to offset.
Now, let me ask you this. In those cases, I follow you, and I understand your argument that they're applicable. Are there any other cases where there is essentially another overlay of an offset? In other words, if I'm correct, there's the amount owed and then an offset based on the damages caused by the contracting party who performed services for which they weren't paid. But here we have one more overlay of a set off, and it was pretty big and was pretty significant.
Have not found a case of a double offset, if that is what you'd want to coin that. But I believe the same principle applies that applied like in Moritz, which was contested.
Well, doesn't it apply in the opposite direction then? Because they're like, oh, wait a minute, well, you failed, that there was an offset. Oh, well, there's another offset. So
it would apply if this was the net judgment rule was in effect. And that's why I'm saying that the court considered the set off, and its statement and near the end of the ruling or the order that said that, well, it doesn't matter about the set off. It's because the court had already found that both sides had prevailed on a significant issue. And when both sides prevail on a significant issue, the court has discretion under Tritech to say no prevailing party exists. And that's what the court did in this case.
I don't think you're taking into consideration the test is announced by our 2019 decision. And again, I think it's getting afield here, but I do not see, and I'd like you to answer this question.
Sure.
What benefit did your client achieve by going to trial? I understand that I woulda, coulda, shoulda. We didn't think we were going to be subject to an offset. We thought we were going to win more than half, but you didn't. The offset was upheld. The set off was upheld. The jury award was 50%. So at the end of the day, you walked away with nothing. And had you known from the get-go that would be the outcome, of course you wouldn't have gone to trial. Hindsight's 2020. But that being the case, I don't see where your client achieved any benefit that it sought by going to trial. What benefit?
Well, it's easy.
You're saying that under some of these older cases, it's a benefit to have a fact finder say that that Hayward Baker was 50% at fault. So what? What benefit is that?
Well, Your Honor,
you don't go to trial in a commercial construction case for principal, right? You go for cash.
Well, we believe that the cost of remediation and restoration exceeded the $290,000 contract amount, and that they were not entitled to the set off.
I understand that, but it was upheld.
The
The court said
benefit,
it's irrelevant, but I don't see how it's irrelevant.
well, it's not, just because a set-off.
Let me get back to just this one question, and I'll back off of you for a minute. What benefit, what tangible economic benefit was achieved by going to trial?
The benefit.
What did you achieve that you didn't already have?
No, well, we didn't have a ruling by the jury that HBI.
And that ruling is of what value?
Well, it was held to be it's the only one we have, and it was for $272,000 event.
Which you already had collected from Zurich.
We had already expended $336,000 in attorney's fees to get $450,000 settlement. And we reserved the right to pursue and contest the set-off in that settlement. And both parties knew that where we stood on that. All DFI wanted in this case was to be made whole for the remediation and restoration. And the problem is between HBI and Zurich jerking our client's chain and basically saying, oh, we'll agree to remediate. And then 6 months goes by. And then the insurance company coming in, oh, by the way, we don't agree, you're the additional insured. The client has to sue them and it gets removed to federal court. That becomes contentious. And just to get rid of it, we try to settle it. And again, it doesn't make.
Counsel, I know there's a lot of water under the bridge. I get that. But at the end of the day, you have to be able to define what benefit the trial was to your client. And that's what I still haven't heard.
Well, that's the benefit that
I know there were goals, but were there benefits?
Those are the goals, I believe, that are set forth by not just TriTech, Prosperity, and Moritz, the 3 Supreme Court cases that deal with this issue, in which they didn't receive any monetary benefit at all. So if you're viewing it as monetary benefit, there is no benefit. But those Supreme Court cases held otherwise, that there was. And
let me work with you with that for a moment. What non-monetary benefit was there?
Well, the non-monetary benefit was the fact that the only party held to have breached the contract and responsible for the water intrusion, sewer damage, and grout damage in the stormwater vault was HBI. They're the ones that were held responsible. Now, is that a Pyrrhic victory? If the court rules that that's not a benefit, then you're right, where there is no benefit.
Well, okay, let me ask you this. Is it necessary for your position under TriTech that the trial court was within its discretion to award no fees? Is it necessary for that position to conclude that your client achieved a benefit? In other words, is it necessary to affirm on an abuse of discretion standard a finding of no prevailing party fees that both parties prevailed on some significant issue?
That's a good question, Your Honor. I don't believe so. And the reason I don't is
then what is the rationale under TriTech for no fees?
The rationale
One
is
party
that
has prevailed on the significant issues with a benefit and another did not. What would be the rationale under TriTech for, in other words, I'm assuming an offsetting rationale for the idea that there's no fees to be awarded.
It would be equity based on the fact that by awarding attorney's fees to HBI, it would result in an unjust reward to a party whose conduct caused the damage and the failure of the contract. They're the ones who started this whole thing and damaged it. It would be unfair to award them attorney's fees. And I believe the court has discretion based on equity. And the opposing counsel cites Tubbs. Tubbs was a voluntary dismissal case, but the court looked at equity every which way but loose, didn't find out what benefit was occurred. They looked at something that was well beyond outside the realm of possibilities. They looked outside of the case and found that, hey, that the reason that case was dismissed is because it was moot, because a senior lien holder had already filed suit to foreclose a lien and it would have wiped it out. That was one thing. And
which case was that you're talking about? Just real quick, I apologize.
Tubbs.
So Tubbs supports, let me just to summarize for my own benefit, your position that even if and I don't want to put thoughts or words in Judge Black's head, but even if, as Judge Black insinuates, there's a possibility that your client did not achieve any benefit,
I think
we could still find that it was not an abuse of discretion for the trial court to have awarded no fees, even though the other party did prevail. Both parties prevailed on a significant issue, but the issue on which they prevailed did provide a benefit, either by way
I believe that's
of
correct.
judgment or by avoiding further liability.
I believe that's correct, Your Honor. I believe that Tubbs is an example of this court thinking outside the box and using equity to say it's just unfair to award attorney's fee to against someone who was trying to, who volunteered, you know.
But doesn't that involve a finding of fact that the trial court should have made in the first instance? Did the trial judge here do that? Was that argument made?
Well, the trial judge in evaluating it found that DFI prevailed on a significant issue of by the jury awarding the money it did in the jury verdict and finding HBI responsible. And I think you look at that as the equity. If they're the ones that caused the harm, it would be unfair to award them attorney's fees.
And that's an analysis you're making. I don't think the judge actually used those words or that intonation. I think you're reading into the record. Am I right on that?
Well, I think you're right. I think you have to read into it a little bit in order to get there. The same thing you would in Tubbs, which, by the way, this court held that there were two other cases suing on a promissory note in another county and said, oh, we've got to consider those too. Those are still ongoing. It wasn't even.
You've used up your time, but we've peppered you pretty good. So I'll give you another half minute to summarize.
All right. Thank you, Your Honor. With regard to the stipulation, that was agreed to. If you look at from the very beginning, the position of DFI has been that the $290,000 would be credited, but it was going to be oversought or set off by the remediation costs. Trying to think of anything else.
Well, that goes by pretty quick.
The final judgment, this is not the net judgment rule. We would ask the court to apply equitable principles to find that HBI is not entitled to attorney's fees and that the court had discretion and did not abuse that discretion in finding no prevailing fee.
All right, fair enough. Mr. Carey, you had 4 minutes left for rebuttal.
Thank you, Your Honor. What counsel for Diaz-Fritz is arguing is that this court should throw away the rule set forth in Moritz and in Tritech and adopt some new standard of equity. We have a rule, and that rule is that the prevailing party is the party who prevails on a significant issue in the case that achieves some of the benefits sought by the parties in bringing suit. Two prongs to that. Hayward Baker satisfies most where the prevailing party were entitled to fees. The only argument that can be made to the contrary is that Diaz-Fritz somehow satisfies that, but they don't, because they fall short on the second prong. They achieve no benefit. I listened to Judge Black, and by my count, he asked Mr. Nesbitt 4 times, what benefit did your client achieve by going to trial? And he never received an answer. If you go scour through their brief, there's not an answer to that question. The answer is quite simple. They achieved no benefit.
You would concede that that if both parties prevailed on significant issues, and both parties achieved benefits in so doing, either benefits meaning they won some money or they avoided a worse outcome, that the trial court would not have abused its discretion by saying there's no prevailing party fees.
I guess I need no more facts on that, how close a case that would be. You know, for instance, if there was no set off and that the jury verdict would have stood as the judgment, that possibly could have been a no prevailing party attorney.
You'd agree that a benefit is not on, I assume so, because you were beyond the net judgment rule.
Sure.
You'd agree that a benefit could be constituted by either an actual award of money, or an avoidance of further liability.
Exactly.
Right?
In the first case, for example, if Westfield would have shut us out, would have gotten a 0, Westfield could have been the prevailing party, even though it recovered, no judgment. However, they didn't. They got hit with the entire amount we sought. So therefore, we achieved the benefit. They didn't. I think what needs to be kept in mind is that this lawsuit, this trial, which Diaz-Fritz forced after 4.5 years after having received $450,000, this trial was not an academic exercise to determine who was responsible for what percentage of the damage. This trial was about money, as Judge Black says. Both parties were seeking money. They wanted $581,000. We wanted $290,000. Westfield wanted to walk away with nothing. There's only one person who achieved their litigation objective. That's Hayward Baker. We're the prevailing party, and we should be awarded our fees. So we'd request that this court reverse, remand to the trial court with directions to find Hayward Baker the prevailing party and award attorney's fees both on the trial court and on this appeal. Thank you.
All right, so that concludes
Thank you.
this case. Thank you both. We're going to take one more case on the 9:30 docket, and that's the Lawson Carter as first representative of the estate of Holly Carter and William Rambam, PA.